We're here in two cases of State of Ohio versus Eric Ruskin, case numbers 24 CR 967 and 24 CR 1174. Defendant is present, represented by defense counsel in case number 24 CR 967, Brent Urinkar, in case number 24 CR 1174, Rush O'Connor. We're here today for a change of plea. States made the following offer to the defendant for a global resolution to both cases. In regards to case number 24 CR 967, the offer is a plea to count 1, complicity to illegal conveyance, and count 5, illegal conveyance of drugs of abuse under the grounds of a specified governmental facility, both felonies of the 3rd degree. In case number 24 CR 1174, count 1, theft, and count 3, receiving stolen property, both felonies of the 5th degree. State has also said that it would recommend in total for both cases 72 months, and the defense does not need to join in that recommendation.
Thank you. Mr. Urinkar, regarding that 24-967, does that sound accurate?
That is accurate.
Mr. O'Connor, same thing for you regarding case 24 CR 1174, is that accurate?
That is accurate as well, Your Honor.
Thank you. Mr. Ruskin, were you able to hear what both the prosecutor and your attorneys had to say regarding what they believe your intentions are here this afternoon?
Yes, sir.
They indicated to the court they believe it's your desire to withdraw your previous entered pleas of not guilty and enter plea of guilty to charges in each of these 2 counts, specifically in 24 CR 967. You'll be pleading guilty to count 1, complicity to illegal conveyance, and then count 5, you'll be actually pleading guilty to illegal conveyance of drugs into a detention facility. Both of those are felonies of the 3rd degree. All the other counts of that indictment, the 5 other counts, would get dismissed. In case 24 CR 1174, it's been represented you'll be withdrawing your previous entered plea of not guilty and pleading guilty to counts 1 and 3, theft and receiving stolen property. Any remaining counts will be dismissed there as well. We're doing a pre-sentence report and all that?
Yes, Your Honor.
So I'm going to defer sentencing to get some evaluations completed, come back on a future day where the state has indicated it'll be recommending no more than a total of 72 months, but you are free to recommend to the court whatever sentence you think is the right thing to do. Is that your understanding of the discussions that took place between your lawyers and the prosecutor, most importantly, what you want to do here today?
Yes, sir.
Well, before I can accept your guilty plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, all the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those matters, I need to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer so you could ask them questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
All right. Let's get started then. Now, there's 2 separate cases here. These rights I'm advising you of, they apply to both cases. I'm not going to go over them twice, one for each case. If there's anything that applies to one case and not the other, I'll make sure I point that out to you. But otherwise, everything I'm telling you applies to both cases, all right?
Yes, sir.
All right, and we'll get started. How old are you, sir?
39.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this afternoon, have you any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
No, sir.
Not even prescribed medication? Nothing?
No.
Now, you would have received a copy of the indictments in this case previously. Those are the documents that set forth the specific charges you're accused of committing. Do you remember getting those at some point?
Yes.
And at some point, did you have the opportunity to review those?
Yes.
All right, we're going to start off with the first case, 24 CR 967. In that case, you're charged with 7 different charges. You're pleading guilty to 2 of those. I'm going to go over those 2 counts with you. If you have any questions, make sure you ask. But in count 1, what's alleged here and what you're admitting to is on or about March 22nd, 2023 in Lake County, Ohio, that you did knowingly aid or abet Shannon Hinton and or Demetria Stewart and or Joshua Brown and or D'Angelo Archie and or Jeffrey Mithke and or Dustin Raleigh in committing illegal conveyance of drugs of abuse under the grounds of a specified government facility. That conduct constitutes the offense of complicity to illegal conveyance of drugs of abuse under the grounds of a specific governmental facility. It's a felony of the third degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, sir.
Any questions about it for me?
No, sir.
Now, the other count you're pleading guilty to is count, I believe it's 5. Is that right? Count 5. In count 5, what's alleged here and what you're admitting to is on or between March 24th, 2023 and April 12th, 2023 in Lake County, Ohio, that you did knowingly convey or attempt to convey under the grounds of a detention facility a drug of abuse. That conduct constitutes the offense of illegal conveyance of drugs of abuse under the grounds of a specified governmental facility. It, too, is a felony of the third degree. Do you understand what you're charged with and pleading guilty to in regards to count 5?
Yes, sir.
Any questions for me about that?
No, sir.
Now, in case 24 CR 1174, there's 4 counts in this indictment. You're pleading guilty to 2 of them. Count 1, which is one of those charges, alleges on or about August 11th, 2024 in Concord Township, Ohio, Lake County, Ohio.
Sorry to interrupt, Your Honor, but they would, these offenses would be amended so that each count is accounting for all the property. So for count 1, it would be property that is listed there, the MacBook Pro and sunglasses. And some of the property from count 2, that being the clothing, wallet, and purse belonging to Hannah Zedek.
Okay.
And then count 3 would be for Chase debit card and a PNC debit card belonging to Hannah Zedek.
What's the other card for count 3?
A PNC card.
Okay.
Thank you.
Any objection to those amendments?
Your Honor,
Ms.
Zagretsky made us known of that when the offer was made, so no objections.
Oh, that's not your case.
Not my case, but no objection for the record.
Did you hear that? You're aware of that, Mr. Ruskin?
Yes, sir.
All right. So let me start over then. So count 1, which you're pleading guilty to as amended, alleges on or about August 11th, 2024 in Concord Township, Lake County, Ohio, that you did with purpose to deprive Joseph Medlin Jr., the owner of property, being a MacBook Pro and sunglasses, as well as Hannah Zedek, and the property involved with her would have been, the credit card, was that part of that? Or just the clothing, wallet, and purse?
Yes.
Clothing, wallet, and purse that you knowingly obtained or exerted control over that property without the consent of either of the owners or anyone else authorized to give consent. It's further alleged the value of the property was over $1,000. So that conduct constitutes the offense of theft. It is a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in that count?
Yes, sir.
Now, in count 3, as amended, it's alleged, and what you're admitting to is on or about August 11, 2024 in Concord Township, Lake County, Ohio, that you did receive, retain, or dispose of certain property, being a Chase debit card as well as a PNC debit card, both the property owned by Hannah Zedek, and that you knew or had reasonable cause to believe that those cards were obtained through the commission of a theft offense. The property involved here is considered a credit card, which constitutes the offense then of receiving stolen property, a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to amended count 3?
Yes, sir.
Any questions about that for me?
No, sir.
Well, then, before I can accept your guilty plea to the charges that I just read to you, these 4 charges in each of the cases, I need to make sure you understand all the rights you are giving up. And you do have the right, first of all, in each of these cases to have a trial. And that trial could be to me as a judge, or I listen to the evidence and I make that decision whether you're guilty or not guilty. But you also do have a constitutional right in each of these cases to have a jury trial. And that would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present Those jurors would weigh and consider all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be unanimous. What that means is all 12 of the jurors would have to agree together, one way or the other, as to each individual charge, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a trial in either of these cases?
Yes, sir.
Now, if we had a trial in either case, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. Because she has the burden of proof, what that means is that it's her job, or she would bear the responsibility, the obligation to prove you guilty before you could ever be found guilty. You're presumed innocent of all these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when I talk about this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt, which is the highest burden of proof there is in our justice system. And what that actually means is it's the amount of the evidence, the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of these charges beyond any reasonable doubt before you could ever be found guilty of any of these charges. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least in order to try to do that, the prosecutor will call witnesses to come to court to testify and answer questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyers would have the right to ask those same persons questions for you on your behalf. That's called cross-examination. They could ask him anything they wanted to, within certain rules. You understand that?
Yes, sir.
You understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You'd call your own witnesses to come to court and testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that, and you're not required to do that, but you have a right to do that if you want to. Do you understand that?
Yes.
And you further can request this court issue an order. We call that order a subpoena. And what a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes.
You also have the right at a trial. You could choose to testify on your own behalf if you wanted to. But you also do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but most importantly, the prosecutor here, she's not allowed to call you as a witness and force you to get up on the stand and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Further understand that if we went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, sir.
All right, well, do you have any questions at all for me regarding any of these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Do you understand a guilty plea is a complete admission of guilt? So it means you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you'll subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as possible sentencing goes, in case 24 CR 967, those are the two illegal conveyance charges. Those are each felonies of the third degree. Those each carry with them a possible prison term of a minimum of 9 months, a maximum of 36 months, or certain increments in between of either 12, 18, 24, or 30. So if I determine a prison sentence is warranted on either of those counts, I'd select the number 9, 12, 18, 24, 30, or 36, and that'd be the number of months in prison you'd have to serve for that particular count. Do you understand that?
Yes, sir.
Now, since there are 2 counts here and the separate dates involved, there's 2 separate incidents. If I impose a prison sentence, I would impose it on each count, and then as the judge, I have the discretion to run those prison terms either concurrent or consecutive to each other. Concurrent means together, you serve them at the same time. Consecutive means one after the other. You'd serve whatever prison term is ordered on the first count, finish that, and then serve whatever prison term is ordered for count 5. You understand that?
Yes, sir.
So with both of these cases together, or both of these counts, I should say, together, you're looking at a maximum possible prison term of 72 months or 6 years on this particular case. Do you understand that?
Yes, sir.
Now, in case 24 CR 1174, you're pleading guilty to 2 felonies of the 5th degree. Each of those are punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, sir.
And again, since there are 2 separate charges here, as I mentioned with the other case, if I impose a prison sentence, I would impose it on each count. And as the judge, I can run those prison terms concurrent or consecutive. So in this particular case, if I gave you the maximum sentence on each count and ran them consecutive, you're looking at a maximum possible prison term of 2 years. You understand that?
Yes, sir.
And then with both cases together, I could run those consecutive or concurrent as well. With both cases together, I need to make sure you understand the maximum possible sentence you face by pleading guilty here today. With both cases, it could be, what would that be, 8 years in prison. You understand that?
Yes, sir.
Are you currently on probation or parole or post-release control in any of the courts or agencies?
I'm on parole. I'm
You are?
PRC.
Okay. Were you on PRC at the time you committed both of the charges in both of these cases?
Yes, sir.
I need to advise you that if a person commits a new felony charge when they are on post-release control, the judge who is sentencing you on the new cases, whether it's the same judge or not that you're on PRC for, does have the ability at sentencing to, or the discretion at sentencing to terminate your period of post-release control and impose an additional prison term of anywhere between 12 months or the amount of time you have left on PRC, whichever is greater. So, how much time do you have left? About
About a year, little less than about a year.
well, if it's less than a year, I can give you an additional year on each of these. If it's more than a year, I can go up to whatever time you have left. If I were to do that, it's not mandatory or required to do that, but if I did, whatever prison term were imposed for those post-release control violations would have to be served consecutive to whatever sentence I give you on the underlying cases. You understand that?
Yes, sir.
All right. Do you have any other charges pending against you right now?
Not that I'm aware of. Besides, which one?
Bedford and Shaker.
In Shaker, Soul, the one I've already went to court for, and they bonded it over. It was from before. They're old. They were old from back before all this happened, and yeah, I'm taking care of those right now. I've already went to court for it, and
Well, I'll tell you the only reason I ask. Are any of them felonies?
the one is
If you are sentenced to a prison term on another case before you come back here, that doesn't sound like that's going to happen. The timing of it, you're just.
yeah.
But if you were and you're sentenced to a prison term, I would have the discretion at sentencing to run a prison term in either of these cases, concurrent or consecutive to that. But I can only do that if you've already been sentenced. If a sentence has been imposed, a prison term has been imposed, I can't do that to some possible future unknown sentence. I can't say my sentence is going to be consecutive to whatever sentence you get out of that case. I can't do that. It's already got to be imposed. You understand that?
Yes, sir.
Now, with both of these cases, if a prison sentence is imposed upon your release from prison, you could be placed on post-release control for these. It's not mandatory for either of these cases. It's up to the parole authority to decide that. I don't have any say in that. But it could be for up to 2 years in each case. You understand that?
Yes, sir.
And if you were put on post-release control in either of these cases and you violated any of the conditions of your post-release control, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by this court. Do you understand that?
Yes.
Now, aside from the possible prison sentence, there's other sanctions that could be ordered. You could be fined in both of these cases. In 24 CR 967, those are the two conveyance charges. Each of those carry with it a possible prison sentence of up to $10,000. Do you understand that?
Yes.
So with that case altogether, there's a possible fine of $20,000. Do you understand that?
Yes.
In the other case, 1174, two of fives carried with them each a possible fine of $2,500, so that's $5,000 maximum fine in that case. Do you understand that?
Yes, sir.
And with both cases together, $25,000 will be the maximum fine. Do you understand that?
Yes.
Now, you could also be ordered to pay court costs in each of these cases or reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes.
Excuse me. You could also be ordered to pay restitution, if that's applicable in either case, for any economic loss any victim may have suffered as a result of the conduct. Do you understand that?
Yes.
Now, a few moments ago, I explained the possible prison sentence you face. I did use the word possible because in both of these cases, prison is not mandatory. You are eligible in each case for community control sanctions, which is also sometimes referred to as probation. Do you understand that?
Yes.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I will consider that if that's what you're asking for. I'm going to look at all the information that's presented to the court, and then I'll make the decision I think is the right thing to do. Is that, you understand that?
Yes, sir.
Now, if you were put on community control sanctions, it could be up to 5 years total, and as the judge, I had the discretion to order a wide variety of rules or conditions for you to follow. One of those conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes, sir.
Further, if you are put on probation and you're violating the conditions of your supervision, we would have a hearing to see if you're what we call a probation violator. And if it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, including an order that you serve time in jail. Or I could terminate your probation and send you to prison at that point. And if I did it at that point, again, it could be for the period of time I told you earlier. With both cases, that could be a total of 8 years. You understand that?
Yes, sir.
Lastly, when we do come back here for sentencing, you're going to have the right at that time say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. They can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever lawyers have to say at the time of sentencing regarding what they think the sentence should be, it is just what it says. It's a recommendation, and I don't have to go along and follow that if I don't think that's the right thing to do. Do you understand that?
Yes, sir.
Do you have any questions at all for me regarding the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time on both of these cases to talk about the cases with your lawyer, go over the reports with them, have them answer your questions?
Yes.
Are you satisfied with the advice and counsel of your lawyers?
Yes.
Have either of them made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here today?
No.
Have you been threatened or coerced in either of these cases to enter your plea of guilty?
No.
Are you entering the pleas freely and voluntarily?
Yes.
All right, then. Do you have any questions for me at this time regarding anything we've just talked about, the rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions?
No, sir.
Do you need any more time to speak with either of your lawyers regarding either of these cases?
No, sir.
All right, then what we're going to do at this time is the prosecutor is going to explain for me what she believes the evidence in these cases would show if we had a trial. I want you to listen to what she says, because then I'll have some follow-up questions for you, all right? Which one do you want to do first? I'll leave it up to you.
The older case, Your Honor, 967.
Okay, we're going to do the conveyance cases first. Ms. Zagreski, I'm sorry.
No problem. The evidence in this case would show that on March 22nd of 2023, in Lake County, Ohio, illegal conveyance of drugs of abuse onto grounds of a specified governmental facility was committed when drugs were brought into the Lake County Jail through a void created by a window in a cell on the 4th floor. The plan to do this was initiated by Shannon Hinton, who is the defendant Eric Ruskin's bunkmate on the 4th floor. Shannon Hinton's girlfriend was Demetria Stewart, and the defendant was in communication with her and knew her to be his girlfriend. On the date that this occurred, on March 22nd, the defendant went into the cell where there was a void, Joshua Brown's cell. He assisted by tearing mattress sheets to create a line that would come out of the window and drop down into the parking lot and road next to the jail. D'Angelo Archie was driven by Jeffrey Mithke. D'Angelo Archie then put narcotics on the end of that mattress sheet line that was constructed, and then the drugs were lured into the 4th floor of the jail. During that time, in order to orchestrate the driver with the individuals in the cell, the defendant allowed his PIN to be used by Shannon Hinton and also made calls himself to Demetria Stewart to confirm that the driver and the other individual were coming with the narcotics. The defendant participated in tearing up the sheets. And when interviewed about that incident, the defendant admitted to these acts and showed complicity to the illegal conveyance. Joshua Brown received some of those narcotics and overdosed in the jail. This initiated an investigation by the sheriff's office as to how the drugs came in. That's how this was found out. And then in reviewing more video and jail calls, sheriff's office became aware of drugs also coming into the jail through USBs disguised as legal discovery. The defendant, between March 24th and March 29th, had those USBs being brought into the jail in a Sokol law firm envelope. When investigators contacted that law firm confirmed that they did not represent the defendant and had not sent anything to the jail. Sheriff's office had the USBs sent to the Lake County Crime Lab, and one of them was found to have dyspropanol, fentanyl, and fentanyl residue on it. The defendant also sent messages to Demetria Stewart in reference to those USBs about paying her for those narcotics and confirming that he had gotten his discovery. Demetria Stewart was the individual not in the jail who had packaged the USBs and mailed them in. And those are the facts for that case.
Thank you. Hang on, let's do this one at a time. So, Mr. Ruskin, were you able to hear what the prosecutor had to say regarding what she believes the facts in 24 CR 967 would show regarding counts 1 and 5?
Yes.
What, if anything, do you have to say about those facts as she presented them? Are they accurate? Did you do what she said in regards to each of those cases, each of those counts?
Yes, sir.
Very well, then, regarding count 1, charging with complicity to illegal conveyance of a drug of abuse under the grounds of a detention facility, a felony of the 3rd degree, what is your plea to that?
Guilty.
And regarding count 5, charging with illegal conveyance of a drug of abuse under the grounds of a detention facility, a felony of the 3rd degree, what is your plea to that?
Guilty.
All right, Mr. Gretzky, let's move on to 24 CR 1174, please.
In regards to that case, the evidence would show that on August 11th of 2024, the defendant entered multiple vehicles in Concord Township, Lake County, Ohio, without the permission of the owners, and then he took property from the vehicles without the permission of those owners. Specifically, he took a MacBook Pro and sunglasses from Joe Medlin, and a purse, wallet, and sunglasses from Hannah Zedek. The value of the property from those individuals was over $1,000. He also took debit cards, Chase and PNC debit cards that belonged to Hannah Zedek, and retained those and used them in multiple locations to make purchases. By obtaining the surveillance footage from those purchases, officers were able to identify the defendant as the individual with the cards. When he was arrested, he was also wearing the same outfit as when he was on video.
Thank you. Ruskin, were you able to hear what the prosecutor had to say? The evidence would show, in this case, regarding these two counts, if we had a trial.
Yes, sir.
And what, if anything, do you have to say about these facts? Are they true? Did you do as she said?
Yes, sir.
So in regards to count one, charging you amended count one, charging you with theft, felony in the 5th degree, what is your plea to that count?
Guilty.
Regarding amended count 3, charging with receiving stolen property, also a felony in the 5th degree, what is your plea to that count?
Guilty.
All right, I have in my possession at this time 2 documents. They're each called a written plea of guilty and judgment entry. They're identical except for the specific charges that go along with each case. But they set forth everything we've just talked about. Before I can accept your plea, I need to make sure you understand what's in these documents and that you signed them here in open court. Now, my understanding is that before I came out here in the bench, you had a chance to go over these documents with your lawyer. Is that correct?
Yes, sir.
First start with Mr. Uranka. Is that accurate? Did you review this? And this is 24 CR 967. This form with Mr. Ruskin and read it over with him?
I did, Your Honor.
Did he indicate an understanding to you?
He did.
Mr. O'Connor, same questions for you in regards to 24 CR 1174. Did you do that?
Yes, Your Honor.
And did he indicate an understanding of it to you?
Yes, Your Honor.
Is that all accurate, Mr. Ruskin? You went over these documents with your lawyers?
Yes, sir.
Any questions for me about what they say?
No, sir.
You understand what they say?
Yes, sir.
It also appears that you signed each of these documents. Did you in fact sign them?
Yes, sir.
Mr. Uranka, you witnessed that?
I did.
Mr. O'Connor, you as well?
I did as well.
And Ms. Zagretsky?
Yes, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in open court with his lawyer. Excuse me. He was advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of all those rights. The court further finds the defendant does understand the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, and this is in case 24 CR 967, of complicity to illegal conveyance of a drug of abuse under the grounds of a detention facility. It's a felony of the 3rd degree in violation of 2923.03A2 and 2921.36A2. Also find the defendant guilty of count 5, illegal conveyance of a drug of abuse under the grounds of a detention facility. A felony of the 3rd degree, violation of 2921.36A2. The remaining 5 counts will be dismissed at sentencing. In regards to 24 CR 1174, I'll accept the defendant's pleas. Find the defendant guilty of amended count 1, theft, a felony of the 5th degree in violation of 2913.02A1, as well as amended count 3, receiving stolen property, a felony of the 5th degree in violation of 2913.51. Counts 2 and 4 will get dismissed at sentencing as well. Sentencing in each of these cases, however, will be deferred. I'm going to order a pre-sentence report investigation, drug and alcohol evaluations, and victim impact statements. I'll continue defendant's bond in each of these cases. So in that regard, your bond's being continued. There's nothing further you need to do in that regard, except to comply with the conditions of your bond. The bond's being continued with all the same conditions that were previously ordered at arraignment. One of the conditions is that you don't use any drugs while you're on bond. Maybe a request to submit urine screens. If you do, you must do that, and they have to be negative. A positive screen would result in your bond being revoked and a warrant being issued. You understand that?
Yes, sir.
So you're going to leave here now. You're going to go to the probation department, fill out some initial paperwork, and get your dates to come back. So make sure you do that when you leave here.
Yes, sir.
I think that covers everything. Mr. Gretzky, anything else?
No, Your Honor. Thank you.
Mr. O'Connor?
Nothing else, Your Honor.
Mr. Ranker?
One last thing. I think his address might have updated, so I might submit a filing to change his update. I believe when we were last here, he resided out in Geneva, so I think that address is on file, but that's just something I might double check.
Okay, but make sure you get the correct address.
Yes.
Well, what is your address?
3583
that's
Austin
the
Road.
Austin Road, Geneva, Ohio.
That's the one you
Yeah.
have?
Yeah.
Okay, make sure you get that to probation.
Yes.
All right,
Yes, sir.
Thank you.
Thank you.
Thank you.
Thank you, Your Honor.
All right.
Does he have, so he has permission to be in Ash, I mean, I'm
I
not-
believe so.
I don't have, I grant it if he doesn't, so he's allowed to be there.
Thank you.
All right,
Thank
thanks.
you.
We're hearing case 24 CR 727. This is case captioned State of Ohio versus Scott Tartaglio. Present in court is the defendant, who is accompanied by his attorney, Mr. Chad Mulkey. We were previously here on November 12th, 2024. At that time, the defendant entered a plea of guilty to count 1, possession of dangerous drugs, a felony of the 5th degree, along with a voluntary forfeiture. This matter was referred to the Lake County Adult Probation Department for a pre-sentence investigation and report, as well as a drug and alcohol evaluation. Those reports have been completed. The state has had an opportunity to review those reports and is ready to proceed with sentencing. The defendant's bond has been revoked, and there are 24 days of jail time credit. Thank you, Your Honor.
Mulkey, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
I do, Your Honor. Thank you. May it please the court counsel, Your Honor, after reviewing my client's pre-sentence report and reviewing that with him and my meetings with him, Your Honor, it is clear that he has a problem with substance abuse. Your Honor, he had some trouble admitting that, but based on his history and what he reported on his pre-sentence report during his interview, Your Honor, it's hard for him, I think, to acknowledge that he needs that help, but nevertheless, he does need it. His adult record consists of felonies back in 2010, 2011. Looks like he successfully completed probation in 2013. But his drug of choice are painkillers, Your Honor, so he would be asking the court for some guidance, services, treatment. I've explained to him the jail treatment program as an option to him. He's of course willing to partake in that program and come up with some aftercare for that, Your Honor. And so I know the court's concerned that he, with his positive test, which led to a bond revocation, and his being less than forthcoming with the court, again, all indicative of somebody in need of services, in need of help with their substance abuse issues, which he does have, Your Honor. So court may inquire of my client. He may want to speak to that effect as well. Thank you, Your Honor.
Thank you. Mr. Tartaglio, you have the right to address this court before sentencing. You can say anything you want. Is there anything you want to say at this time?
I think he put it pretty clearly. Ever since I got divorced in 2000, my life has been up and down. I've been a little bit of mental health issues too. I was in and out of programs for that. But last year I made a lot of bad decisions, bad judgments. I'm sorry. Please have mercy on me.
Well, the problem is you won't admit that you have an issue here. You're just lying to everybody. Everybody you've talked to, it's a different story. Your marijuana use, let's start with that. You were here for your change of plea. You told your lawyer that you're going to test positive for marijuana because you had a gummy the day before.
Yeah.
Then you went to probation and told them that you had marijuana the day before. When you went to the drug and alcohol, you told them you can't remember the last time you used marijuana. And it was the same day. So you just told Nicole that you used last night.
Yeah.
Or the night before the plea. You went to the drug and alcohol evaluation. You couldn't remember when the last time you used. So somewhere in the staircase, when you were going up or downstairs, you lost your memory. Then you tested positive for methamphetamine. You denied ever using methamphetamine to the probation department, but you tested positive for that. You deny that these drugs are even your drugs, but yet your drug of choice is a painkiller, and that's what these happen to be. There's just no credibility there. Everyone you've talked to, we get different answers from you depending on who you're speaking to. So that's not going to work on probation. If you're on probation and you can't be forthcoming and upfront, then it's going to fail. Because if I put you on probation, the purpose is to try to get you help and get you back on track. But when you lie and mislead and misrepresent, it's not going to work. It's not going to work. And that's what you've been doing to me in probation ever since you got involved with us. Why is it that I should believe that you're going to be upfront and open with us when? And I explained to you when you were here last time, you need to be open and upfront with probation because they're going to check and verify what you tell them. And if they're misleading them in some way, they're going to let me know. And that's what happened here. So they really even have to let me know. I could just look at the different reports because you tell different people different things.
I promise if I get another chance, I won't mess this up. I promise I won't. I'm 64 years old. This time I spent in the jail right now, it's just been completely changed my life, my thinking, and everything. I'm telling you the truth. I won't mess it up. I want to try to get my life back together, see my kids again. I was right there. I was taking people back and forth to AA. I was clean for 2 years. And then when I got this charge, I was afraid to go back to AA because people would be talking about me. I should have just kept going.
Anything else you want to say?
No, sir.
Mr. Mulkey, anything else?
Nothing further, Your Honor. Thank you.
Ms. Himmeline for the state.
Thank you, Your Honor. Pursuant to the negotiated plea agreement, the state has agreed to a joint recommendation of community control sanctions in this case. Thank you.
This court reviewed the pre-sentence report and investigation, drug and alcohol evaluation. I've considered the facts and circumstances of the offense involved, the nature of the offense. I've considered everything that's been said here today. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11 of the revised code. As for the factors in 29-29-12, factors indicating the conduct is more or less serious. Nothing stands out factually indicating it's any more or less serious than what normally constitutes the commission of this offense. As for recidivism factors, the court finds the defendant does have a history of criminal convictions. Goes back to 2006, but it was just for a 5-year window there, from 2006 to 2010. And as he indicated, he's 64 years old, so it, didn't get his first offense until, when were you born? 56, 58, something like that?
1960, sir.
1960?
Yeah.
46 years old before he got his first. That was just a misdemeanor. Got 1 prior felony. No, 2 prior felonies, excuse me. 2010 and 11. And then nothing. I'll get comment on that in a minute, but he does have this prior history for 5 years. There's certainly a drug abuse problem that relates to the offense. This is probably the biggest factor in the recidivism, and he doesn't acknowledge it, recognize it. He talks about it, but doesn't think there's really an issue. And mainly, he's not open and upfront about it. There's no genuine remorse in regards to this offense. In fact, he really denies committing this offense. Pills were in his car, and he knew it, but he denies they're his. Now, his drug of choice is painkillers. He's been using them since he's been 28, I think he said, to the probation department. So that's, I don't know, what's quick math, 36 years. But those pills weren't his. Factors indicating recidivism. Oh, I also note for the recidivism factors being more likely is that the defendant failed to comply with the conditions of his bond and using drugs while on bond, which does make recidivism more likely. As for factors indicating it's less likely, the court does note, as I alluded to before, defendant led a law-abiding life for a significant portion of time, up until he was 46 was the first time, and then the last 12 years, there hasn't been anything until this. I guess 11 years is when this happened. This happened a year ago. Under 29-13B1, the court notes, again, the defendant violated conditions of his bond. That overrides any presumption for probation, permits the court to impose a prison sentence I'll make a finding at this time, however, the prison would not be consistent with the purposes and principles of sentencing, and the defendant is amenable to an available community control sanction. Therefore, it'll be the sentence of this court that the defendant be put on community control sanctions for a period of 2 years. How much credit was there? I know you said, told me in chambers.
There's 24 days, Your Honor.
24. For the defendant to serve 75 days in jail. He has credit for 24 he's already served. I'm going to order that he enter and successfully complete the jail treatment program. Follow all aftercare recommendations. On completion of jail treatment, he is to enter, successfully complete the program at either Concord Pines or Lake House. Follow their aftercare recommendations. He should then, at the conclusion of that, live in a sober living residence for at least 6 months. Further conditions, you're not to use any drugs or alcohol. That means no marijuana, no prescription drugs unless you have a valid prescription and you're using it pursuant to that prescription. Must submit random urine screens. They must be negative. A positive screen will be a violation. To attend 3 AA meetings a week and have a sponsor. Obtain and maintain full-time employment. I want you to have one doctor and one dentist that could prescribe you medication. If you have a specialist, that's fine too. But only those doctors that you tell the probation department about that are giving you prescriptions that you can get a prescription from. If you get a prescription from some other doctor that they're not aware of, even if it's a legitimate prescription, but you haven't told them about it, that would be a violation. Further, can only get your prescriptions filled at one pharmacy, and they need to know where that is. If you've been filled at any other pharmacy other than the one that you've told probation about, that would be a violation. Okay. I want you to sign releases if requested so that the doctors can be spoken to if necessary. To obtain a mental health assessment, this will probably be done during your treatment. But follow whatever recommendations are made for any type of mental health counseling. Pay court costs and supervision fees. Specification on this one?
It was a voluntary forfeiture, Your Honor.
Forfeit the drugs that were found. Well, anything else that I should be thinking about here?
The only question I had, Your Honor, is did you want him to complete JTP as soon as possible or the last 30 days of the sentence?
There's only 50 days left to do, right? 49 or something like that, 51 I think. He can get in as soon as he can, and then once he's done, he can be released. If you can put that in there. Upon successfully completing, he could be released to Lake House or what's the other one? Concord Pines upon a bed being available. And if there's any sentence jail time that's left over, that will be vacated. So why don't you write that up in the entry like that? Mm-hmm. So Mr. Tartaglia, you understand all the conditions of your probation?
Yes, sir.
Any questions for me?
No, sir.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another crime while on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, including more jail time, or I could terminate your probation and send you to prison. If I did that, it'd be 12 months in prison. So that's what's hanging over your head. You understand that?
Yes, sir.
All right, Ms. Simone, anything else for the record?
Just bond, Your Honor.
Oh, bond's released. I'm not forfeiting bond. Mr. Mulkey, anything else?
Nothing, Your Honor. Thank you.